fingers crossed. Only been a 15-minute wait. Alright. Now, as you guys know, we've been doing the 5 key things or key aspects in terms of administrative review, being jurisdiction, justiciability, standing, grounds, and remedies. And those 5 things, a big chunk of this subject is the 4th one, actually going through and mapping out what natural justice in this case, but what the various grounds of administrative action are in order to bring an action in the courts and the court system. So if you do go and listen to Jamie's recordings on this, you'll find that each of these is spread out over multiple weeks. Now, given that we're actually missing a lecture thanks to public holiday at some stage this semester, I'm going to try and really include all of the stuff in natural justice, procedural fairness in today. So, sadly, that means that that will be going for the full 2 hours, I would imagine. All right. Just also note, I couldn't get the chat to work. This is taking too long, so I'll leave that for today. All right. Now, a couple of things to note. I've got to go through each week. We're obliged to go through and talk about what this week's lesson outcomes are going to be, and also note that this is both a mix of, I guess, the very practical things you need to know in terms of taking actions in judicial review. But there's also a bit of theory with it as well. And I'd made this comment a few times before, that administrative law and equity are things that judges love to go and analyse and talk about. They're things that are opaque to the layperson. They're in areas of law that legal professionals, people who know a lot about the law and the legal system, spend a lot of time analysing. And in particular, sometimes they can analyse and theorise about some sometimes quite obscure points that often don't really concern us as students, people as academics, people as legal practitioners, and to be honest, people having to deal with administrative law and having to deal with decision makers in the administrative system. So I'm going to talk about some of the theoretical aspects, but I'm going to try and really draw that back to, I guess, the key concrete aspects of what natural justice and procedural fairness are. And just first thing I just want to know is I haven't really delved much and really gone into much depth about the distinction between the two. What is natural justice and what is procedural fairness? For the purposes of this subject, we really don't need to care about the distinction too much. I did, however, put a piece under the week 4 materials by James Edelman, who you may or may not know is one of the High Court judges, and he's about 42 years old. Very, very young guy, so he'll probably be around on the High Court for a really long time. So you guys as practitioners appreciate this guy's going to be on the High Court for almost the next 30 years or so. So just make note of that. But it's a very, very good piece talking about the distinction and some of the history behind that as well. And just also make note that it's not, it is something that the courts have done when they're talking about this area. They will sometimes use different language, and the language can overlap. So while there is, I guess, a theoretical distinction between the two from a practical perspective, judges tend to use the same language when describing both. And it's, I think it's just a helpful thing just to have at the start. Don't pay too much attention if I personally, or when you're reading things, that they make distinctions or don't make distinctions between natural justice and procedural fairness. So a couple of things to note. The first is that it is actually described as quite a practical doctrine. It doesn't sound like it. It sounds like one of those arm-waving, airy-fairy areas of law. But judges, when they talk about natural justice in the broad sense, both judicially in judgments and outside of it, do go and say that, look, natural justice is really a very practical aspect. It's this practical mechanism for maintaining the rule of law, systems of legality. It is fundamentally designed, and when I use the word designed loosely because this thing really sort of evolved over hundreds and hundreds of years, in what we would consider to be, as functional human beings, common sense. These doctrines have come and derived from things that we as human beings have thought that other human beings would look at and just go, of course. It's just something which happens or needs to exist as a matter of course, really for the mechanics of law and government to exist in the first place. Okay. Now, last week we talked about standing, and we talked about one case in particular, which was the ACF case, and how that was a really important one in terms of with this particular area of law. Now, the key important case for natural justice as grounds of judicial review is Coyer and West in 1985. And I'll go through some of the judgments where they've got concurring, so a lot of them sort of agreed, but they expressed it in quite different ways. And what we found is that some of the theoretical writings that have flowed from this have actually come from those decisions and the different strands and lines of thinking that different judges had in that case. But make note, again, as a practical tool in your repertoire as legal students and later legal professionals, that there is always going to be a balance. And this kind of makes sense. We, as law students, legal professionals, people that have been studying this discipline for a few years, have been exposed to this concept before. You would have certainly had at stage one, you would have had Jamie, possibly Neil, possibly Rachel, talk to you guys about the mechanics, if not the minutiae of it, in the broad sense, how and what this thing is about. And it's important to note that judges, while obviously being the ones who have to, at the end of the day, create orders that do things to uphold principles of natural justice, they're the ones you have to go to reach some sort of final determination. That they're also sympathetic to this idea that, look, if everyone was to do this all the time, government ceases to work. It is essentially a practical doctrine, systems of rules. And there is always going to be this balance between the administrative maker trying to do their best to make administrative decisions, trying to do their jobs. Remember that tongue-in-cheek I've mentioned in this subject, one of the big aims of it is to turn you guys into terrible human beings. Part of that is that you're going to make people in government who are making decisions do their jobs and do their jobs properly. All right? But fundamentally, we have to let them do their job. And so it's just make note that while these systems are in place, the purpose of it is to facilitate the practical administration of justice. It's not to be a clog in the machine. And just make note, that's actually a reasonably recent statement by the High Court, that middle one there. Now, you'll find a lot of these cases, because many of them involve refugee and migration type decisions of usually the federal government. They often have codes, or they will be the long-winded name of the particular minister of a particular long-winded department, and then something like ex parte Maya or ex parte Tio or whatever the particular person is in this situation. So when you're doing these things, and I'm thinking here in terms of your exam type situation, just make note, I'm going to understand if you say plaintiff S10 or WZARH, I'm going to understand, and that's the only person from your guys' perspective that you need to actually demonstrate that in terms of your cross-referencing and citations in an exam situation, which is the case that you're associating with. That's the bare minimum piece of information you'll need. There aren't many where there's duplicates and I'll express those, I'll outline those when they come up. Okay, now for those that may have gone and listened to Jamie's material ahead of time, which I do recommend to do, by the way, and go and re-examine it afterwards, there's 3 strands. And unfortunately, this area of administrative law is expressed by different theorists and different judges in slightly different ways. So if you go and get 5 separate textbooks and you're reading about this, they're going to categorize those in their own particular way, in their own particular style, how it fits in their own head. And this is an area where if you go and you're going through these slides or the outline, it isn't going to align necessarily with Jamie's one particularly well, and it may not align with others that you've grabbed from the interwebs or from earlier incarnations of the subject or elsewhere. All right, now, I guess from a very high level analysis of natural justice, procedural fairness, but we'll use NJ as the abbreviation for the remainder of this lecture. We're looking at 3 aspects. Is there, or does the particular decision maker have some form of duty? Is there something implied in terms of what they are doing that means that that decision has to follow the rules of natural justice? How does that manifest itself? That's the first one, because in some situations it's really obvious. Hey, look, the rules that a particular person, or the steps, or the process of the policies that someone's going through will say these must follow the rules of natural justice, and that's how this is to be expressed in this situation. That's usually pretty straightforward. It's trickier when that's not made, or where they've gone outside those particular boundaries for making a decision. And refer to that as the implication question, or the implication principle. Can natural justice be implied into a particular situational scenario? Okay, that's the first aspect of natural justice that we're going to look at. The second one is, look, and this kind of makes sense. You guys remember the Howard government? Well, maybe you don't actually. Oh wow, yeah. I'm trying to think of it. Some of you guys are going to be born this side of the millennium. There was a guy called John Howard. He was a bit of a no-nonsense gentleman, and ran a right-leaning conservative government from 1995-ish through to being spectacularly defeated in 2007. And part of this no-nonsense style of governing is a phrase that you may or may not have heard: turn back the boats. Anyone heard of that phrase? You don't hear much of it these days. You want to know why you don't hear much of it these days? They've changed the method of reporting. So people that would have been considered to have been boat persons don't form part of the reporting system for doing that. So if you do see these great success stories about the number of boats being reduced, and because you haven't heard about it much on the news. It used to be a big thing going back a few years. But these situations, people usually coming through Indonesia from a variety of developing nations, jumping on a boat, sailing to Australia. Why would they do that? Well, once you hit mainland Australia, yes, everything you do and every decision that the government makes is subject to the laws of Australia. And what's a really important principle in the laws of Australia? Systems of judicial review. And in particular, things that the government does, which now become subject to systems of natural justice and procedural fairness. So the government, for quite a long time, was quite keen to stop that. And what's the rule? If Parliament clearly evinces their intention in properly passed legislation and what the courts want to do, who wins? It wasn't meant to be a trick question. Parliament wins. The doctrine of parliamentary supremacy means that what they say is going to win. It's going to trump what the court wants to do. Now, courts don't like it very much when Parliament, and again, there's different sort of reasons and different philosophical frameworks for this, how and why they go about doing this, but courts will generally construe these attempts of Parliament to ouster and stop natural justice from being done in certain circumstances really narrowly. And so this area that we look at in the both theoretical and very practical implications, don't use that word, practical results or manifestations of that. We refer to that as being the exclusion principle, the exclusion question. Can Parliament exclude natural justice, or other bodies exclude natural justice in certain parts of their operation and their decision-making process? And the third thing is okay, sure, we'll assume that there is natural justice is required. It hasn't been excluded. It does exist somewhere along the line. Well, so what? What does that actually mean? What are the actual mechanical steps that a decision maker has to take in order to make or reach that particular hurdle? What things do they have to do? That's the content question. All right, so starting with some theory. Now, I mentioned that there's a little bit of backwards and forwards, argy-bargy in terms of how courts go about construing statutes to try and apply natural justice in statutory processes and decision-making. And some theorists have argued that there is a distinction, this flows from Coyer and West, between the courts, their role being upholding the common law. Common law is how and where natural justice is imported into things, and these are common law rules that we use in order to try and find natural justice and map and model that out. And the opposite of that is some jurists and theorists say, no, in fact, all of these things come from statute. All of the systems and rules that we have involving natural justice, they only work and operate in and around statutes. Therefore, it's really the role of Parliament to go and map these things out. The court's just facilitative. This is where natural justice comes from, with the idea being that, look, Parliament generally does good things. It's Parliament's job as the repository of all of the will of the people to go through and say, we need to have natural justice in things. We need to have some form of transparency. We need to have some procedural fairness most of the time. Because if people didn't like what Parliament did, they'd just vote them out. And that's a theoretical framework, looking between the two of those. Other texts and theorists, and this comes from Craigie, look at these in terms of there being 4 different models, where you have one strand of theory being that natural justice flows from common law rules. Others say that it flows from legislation. Some say that there's some form of universal principles of justice and fairness that transcend those 2 sources. And as a 4th aspect, well, natural justice only appears as a practical concern. So we're really trying to derive what principles of natural justice are from how they are actually manifested in the world. Oh, I can see some glazed looks now. It's all right. Don't have to do a big piece of assessment on this. It's really just for your background knowledge. The third one of these are the strands actually named after the judges. And these 3 are actually, I mean, obviously, they're High Court judges, but their decision in Coyer and West in particular. And this kind of ties in with point 1 as well, this idea that Mason was pushing there to be this very common law centric rules, that everything flows from the common law. Justice Brennan on the reverse of that saying, no, things come from Parliament. And Justice Dean was, I guess you could say, a proponent of this universalization principle, that it doesn't really matter where things come from. But these principles are things that we hold to be self-evident. All right, and just to make note that kind of annoyingly, in Coyer and West, even though we associate Justice Mason with this as the upholder through subsequent cases of common law as being the source of principles of natural justice, this common law implication principle, It actually came in sort of both of their judgments in that particular case. All right, and really the starting point of this is filling in the gaps. Sure, there is such a thing called Parliament. We, the courts, appreciate that it exists and it does have priority. Sure, yeah, Parliament is supreme. We're not doubting that particular principle. What we're saying is that, look, where Parliament hasn't talked about that, the common law needs to step in. The common law needs to paper up all of those cracks in order to uphold these particular principles, long-standing principles of fairness. Really, that's what they're stating there. In fact, I even put a lovely wall of text, which I do not recommend copying down, but there are some key words and phrases that they use here. He's talking here, this is Justice Mason, about common law in a very broad sense. He's saying that the common law has developed over 1,000 years. Does anyone know what year the common law started? It's actually a particular point in time. You ever heard of the phrase time immemorial? You ever heard of that? Oh. Don't ever use that in your history essays. I can tell for a fact they don't like that. It's actually a particular year, 1187, I think it is. Yeah, look it up, Google it. That is when time immemorial started. That's where the common law supposedly sources all of its things beyond that. We know that that's a fiction. We know that these rules have been adapted, and some of them very, very recently. But just make note of this phrase here, that they're saying that natural justice applies in the making of administrative decisions which affect rights, interests, and legitimate expectations, subject only to the clearly manifested will of Parliament to the contrary. And as I'll talk about later on, natural justice, we're looking at judicial review. We're looking at usually government bodies that are making decisions. Natural justice, though, you may be aware of this, actually applies more broadly than that. It can actually apply to other areas, in private areas of law. That is where things start to get really murky. As a result, we won't do that till the very end. Okay. And the font gets smaller. So this is what Justice Dean has to say. Again, still in Coyer and West. Again, he uses the same phrase, rights, interests, status, or legitimate expectations. And again, they say, unless Parliament says otherwise, person given a statutory power. So he's kind of confined himself there. He's not talking about the common law broadly. He's talking specifically about governments here. But if you note this bit here, legitimate expectations of another in his, her, or their individual capacity as distinct from a member of the general public or a class of the general public. What does that sound like? For the tube, for those that have just been to the tube, those that are just about to go to the tube, sounds a little bit like, you know, that second limb of Boyce, doesn't it? And the High Court in the ACF case talked about the area of standing. So that idea of this, and the two overlap quite a lot, the idea of needing to have standing. But in terms of natural justice, these guys talk about this legitimate expectation. Now, I haven't delved too far into this because, again, there's a lot of theoretical stuff arguing one way or the other as to whether that's a valid phrase. For the time being, we'll just assume that it is. Persons with a legitimate expectation of something are required to do that. So these are kind of in accord. And another, probably the largest wall of text that you'll get. Justice Brennan, and his infinite wisdom, has taken the reverse stance on this. And I will summarize that wall. By the way, there is a copy of this in, if you go to Learn JSU in week 4, you usually put a Word document up that has these in there. Somewhere in there, he'll talk about Parliament being supreme. Look, it may be that there are these rules in the common law, but fundamentally, the most important one is that our tradition is that Parliament is supreme. And it's not really the courts, it's not really the common law that should be doing these things. Where there is a statute, sure, we have to read it. The court's fundamental part of their role is to read statutes, and they will follow rules for reading statutes. Some of which are governed by the common law, some of which are governed by interpretive instruments. What's the primary interpretive instruments that you guys have been exposed to in law school? With advanced subjects that you probably would have done in the first semester or first year of law and you've completely forgotten all about. Some of you would have had Van. I had Rachel many years ago. It's the Acts Interpretation Acts. Those rules, they're basically Parliament coming along and saying, hey courts, we don't like the way you've been interpreting statutes, do it this way. And so really that's what Justice Brennan is trying to say here. It's really the domain of Parliament to do these things. That's where these things flow from. All right, so that. Okay, and this was all very nice theoretical fluff, but the High Court in the last 10 years, 10, 12, no, not even that, 7, 8 years, has come and really cast doubt on these two strands, the theoretical strands. So from, I guess, they've overtly said that while it's nice to analyse these things theoretical, it may come from the common law, or principles of natural justice only flow from statute, we don't care. We're just going to go through and do our job, which is to follow what we believe the law, both the statutory and the common law rules are, and apply it. The fact that they have these two things, look, it just muddies the waters, which is always really funny when they're talking about administrative law, making a determination and saying that the existing rules and principles are murky and hard to understand. Because usually, all they're doing is taking all of the existing rules and principles and then adding a new one to make it even harder to understand. But nonetheless, that's where we're at. So in terms of that, the theoretical distinction between Mason and Brennan and Coyer and West, the High Court relatively recently said that it's not very helpful from a practical perspective. All right. That was horrible. Yet, and it doesn't get any better, sorry, for the next 20 odd minutes. All right, so Parliament comes along and says, oi, you people on boats, when we pick you up, we want for you, as people that we're dealing with, and with our best intentions as the executive arm of government of the Commonwealth of Australia, we want to be able to determine ahead of time what you can and can't do in terms of appeal to the courts, in terms of having certain rights of review, in terms of being afforded natural justice and procedural fairness. And so, look, it's well established. Parliament can do this. Parliament can go through, map out what can and can't be reviewed in the courts. And that must be the next slide. Oh, a few slides further down. In Meyer's case, anyway, that's exactly what they did. Basically, the High Court, again, it's a refugee case, where it's gone to the High Court, and the High Court has found, notwithstanding the will of Parliament or the request of the minister in that particular circumstance, that a person is to be afforded natural justice and procedural fairness. So what they did is they crafted a piece of legislation. And they said, look, we want to map this out. And map out what the rules are for natural justice and procedural fairness in relation to migrants, becoming unconventional migrants entering Australia. And the High Court, a few years later, Myers was, I believe, 2001, and they changed law in 2002. And here, the Lamb's case did go to the High Court, and they did talk about it, and they said, look, actually, yeah, you can. Parliament can actually do that. They are supreme. They can tell us what we can and can't do. But we will construe this very, very carefully. You're going to map this thing out. You've got to do it really tight. Because of these fundamental doctrines. Again, this may be familiar. Do you remember studying Coco and the Queen in stage 1? Does it sound familiar? We're talking about fundamental rights. You may or may not remember, but you need to remember because it's really important. It's the one area that the profession come back to the universities and say, we didn't do our jobs properly. The single biggest area of gripes, of moaning and complaining, statutory interpretation. It is something that, to be honest, I think we should do multiple times throughout the degree. You do it in stage 1 in your first semester, you do LA3002, and usually it's all new and fresh, and there's beer to drink, and pub crawls to go on, and other bits and pieces, and it sort of stays there and generally goes away. And so there is a push, and you'll find this too, for anybody here doing Land B, Land 2, whatever it is at the moment, Chris will push to make you guys read statutes. You must go through the RTRA and read it. And part of that is that we've been given the boot up the backside. You guys need to be able to read statutes. That is the dominant, I guess, form of law and lawmaking. That's the thing you're going to be most exposed to. You need to be able to read them. And you may remember from 102, Coco was talking about these interpretive rules, these fundamental principles that we have in our legal system. When you read a statute, what is the dominant approach to statutory interpretation? It's the purposive approach. You did remember that. I think everyone's just a little bit shy, and that's all right. The dominant approach to statutory interpretation, which Parliament has actually enshrined in the various Acts Interpretations Act. 15 capital A, I think it is. Don't quote me on that. Anyway, the idea is that you look and determine what the will of Parliament is. What was their intent for creating every particular section that you read in a statute? But sometimes you can't work it out. And so there are a whole bunch of other interpretive rules. Remember the adjustum generis rule and the syntactic presumptions? And have what when I taught that subject many years ago, referred to as the last chance salon. And that is when you can't determine what the will of Parliament is, or it's still ambiguous. We've used all these syntactic presumptions, we still can't work it out. Okay, let's read the statute in light of certain fundamental rights that flow from the common law. So these things, does this sound vaguely familiar? Just a little bit? One of them, for example, statutes not to be read retrospectively, if they're taking away substantive rights. Criminal statutes, again, as a last chance salon, are to be read down in favour of the accused. These are just rules that the common law have developed over a long time. And one of them, again, mapped out in Coco and the Queen, and then kind of restated by Chief Justice Gleeson and Electrolux, is that in order to remove our fundamental rights, Parliament must be absolutely crystal clear. That's where that comes from. Coco and the Queen, you've got to take away our rights. You must be really clear in doing it. And we need to all know about it. So it's a sort of, as a part of the legislative process, it needs to be, as we're aware, we talk about it. I want to say we. They go to the Senate and they argue, and they go to the lower house and they argue, and everyone know that there's a new series of Rake coming as of this Sunday. You all should watch that, it's excellent. So they have this process that we go through, putting things into legislation. That's fine and good, but every now and then something falls through. And so if Parliament is going to go and remove our rights, they need to be damn sure that that is what they're trying to do. And so here, again, that's a joint judgment. General words will rarely be sufficient for the purpose of removing or interfering with our fundamental rights. In the context of it, often be, and it should be reasonably commonsensical to you guys. You have been exposed to this before, but just make note, the purpose of approach is the dominant approach in statutory interpretation. This comes further down the process. But from our perspective, we are concerned about decisions that are made under enactments, not necessarily reading the statutes themselves as much. All right. And what Chief Justice Gleeson in LA3006 is talking about is this idea of the principle of legality. And that's, this fundamental idea that ties in with the rule of law, that everything is to be interpreted in the context of law. It must be done according to law. So as a result, and I think I've got Meyer's case. It's the third one down. Before what I'd mentioned about having a situation where Parliament didn't like what the High Court did. They didn't like what the High Court did, and so they've gone and created a document that says this is how natural justice applies. And they've used the phrase, this is an exhaustive statement of this area of law. An exhaustive statement. And the High Court has said, look, that actually means what Parliament intended it to mean. They intended for us to get our sticky beaks out of it. They intended for that to be codified. And remember, you guys would have had Luke probably for criminal law. Did you guys talk much about this distinction between a Crimes Act and a criminal code? This distinction, it's quite a key, important distinction. The idea that a code is supposed to encapsulate all parts of the law in that particular document. It goes back to this notion of Jeremy Bentham. A citizen should be able to go to the book, open the book, and see what the law is. None of this stuff that sits in judges' heads, which is, tongue-in-cheek, referred to as the unwritten law. I mean, how difficult is that as a citizen to go through and try and work out, what the underlying law is? What's the trouble with this? Well, where's the definition of the word possession in your criminal code or the Drugs Misuse Act? Where is it? Anyone remember? It's in the common law. It's in the case of Hicote in the mid-80s. So the trouble with codifying things is that you have to define things. You have to define words, usually elsewhere in that same code. Then you need to have words that define the words that are used in those definitions. You can see where this is going, and words that have to be used to define that one. And next thing you know, your criminal code has turned into the Oxford English Dictionary. Dictionary makers don't make law. So we do accept, even when you codify things, it has to use words, and those words have to come from somewhere. Have to be interpreted. And so, because of that, the courts are always going to have a role, because they have to interpret statutes. What does this word mean? And so you can't, again, it's like a dog trying to chase its tail. You can't actually stop these things. It's circular, essentially, in how it's defined and described. And so, again, what they had done as a result of Meyer is to change the law by codifying it, this area of migration law. And the courts did say, later on in LA3006, look, you can actually do that. Courts can do that. We were definitely going to construe it very, very tightly to make sure you have done it. In particular, other grounds of judicial review, like jurisdiction error. You've got to make sure you are actually within your power to do that when you're exercising, doing decisions under that. But fundamentally, they can do it. It's not our job. It's Parliament's job to chop and change those things. And the court has said, given that there are actually a stack load of these cases, the High Court, if you go through and look at their workload, I'd estimate about between 10 and 20% of cases in the last 15 years have involved these sorts of matters. Don't quote me on that, but it's still quite a lot. And the courts have, I said, and Saeed, they talked about this process and said, look, it's just really difficult. It is really difficult to codify things. Parliament has tried, of course they tried. It's a political issue, political football. People arrive in Australia on boats. It's appears at the front of the news. People get all outraged about it. It's a big political thing. It's hard to codify this stuff, though. It's actually quite hard to put it in there and make it, and this is the High Court saying, look, it's hard for Parliament to do that, to stop it, stop us from working our way around it. That's what we, fundamentally, it's our job to go and do. I've got one more, then one break. There's just a couple of points to just make note when we're looking about this principle of legality. The first one is inconsistency. You can, if the correct operation of a statute, just in its very nature, doesn't follow what you would normally consider to be natural justice or procedural fairness, then, assuming that it's been validly and properly formed and the decisions have been made within it, then that's too bad. If we think of examples, taxation statutes, you have to pay a certain amount of money by a certain amount of time. And the fact that it might take you, 12 months to pay your tax bill, well, that doesn't matter. The operation of the Tax Act says you've got to pay it by this length of time. And in terms of doing these things, in terms of having notice, in terms of doing all of the requirements, it doesn't matter. You're still going to be fundamentally liable for that amount of money, even if there have been some mechanical errors in giving you some form of notice and following those systems. Delegated legislation. We talked about this in terms of things that are justiciable or not. If a particular person or body is given the power to create delegated legislation, there's a head piece of legislation passed by Commonwealth of Australia or the state of Queensland in our case, and that can grant power to another body, say the Townsville City Council, to pass particular pieces of delegated legislation. The process of going through and doing this and creating this delegated legislation, that's essentially a legislative task. So we talked about justiciability, probably doesn't fall within the realms of what can be reviewed. Also doesn't really fall within the realms of natural justice or procedural fairness. You don't like what the council does in terms of their bylaws, and remember, they're still governed by the higher level statute. You don't like that parking tickets in Townsville have doubled to be like $50 instead of $25 or something ridiculously low. Why are park tickets so low in the city? You guys may not think this, probably think they're horrific, but you go to a major city, you don't pay $1 an hour to park on the side of the road in central Melbourne or Auckland or other major cities. But if you don't like what the council does, what's your proper remedy? Vote them out. So that's how and where that sits. Now, I think we'll break there. It's about halfway through. If you guys are all right with that, go take 5 or 10 minutes. So take 5 minutes? What do you guys want? 10? Up to you. I'll come back at about 4 or 5 past. Cheers. All right. So, we accept that this thing called natural justice and or procedural fairness exists. So what? What does that actually entail? And that is, I guess, this third aspect, which is the content question. What does it mean? What actually happens in the world? And how do breaches of this actually arise? And broadly speaking, it falls into two categories. And again, these are very practical considerations. This first one is the right to a fair hearing. That is the bulk of these problems or disputes. By bulk, I mean 90 to 99% of the time, it's to do with the fair hearing aspect of natural justice. Audi alterum partem, my horrible, horrible, horrible Latin. I am far too young, it's kind of funny in this class, I'm far too young to have studied Latin at school, so I apologize if I do not pronounce that at all correctly. So this right to fair hearing includes all of the notice provisions and the right for information. I'll go through those mechanical aspects of that shortly. But the second component, which I'm going to talk briefly about at the end, is the rule against bias. Nemo iex in causa sua. And that's to do with the actual nature of the person that you're dealing with, rather than the how your particular processes or procedures have been applied. So judges, both judicially in cases and also extrajudicially when giving speeches and all sorts of things, they do like to start with first principles. And often those first principles go back to very old cases in the common law. And sometimes all the way back to religious texts. They go back to biblical examples and of particular rules or principles that have been around a very, very long time, for thousands of years. The laws of God and man both give the party an opportunity to make his defense, if he has any. I remember to have heard it observed by a very learned man upon such an occasion that even God himself did not pass sentence upon Adam before he was called about to make his defense. That quote was by Coke, I believe, so an old chancellor. It was the chancellor. It's a little bit murky. If you go back a few hundred years, the head of the judiciary and the head of the courts, that role was somewhat blurry in terms of what we would now call the distinction between the Chief Justice and the Attorney General. We think of those now as being two quite separate and distinct things, but you go back hundreds of years, and yeah, often the two were very much similar. Or the Attorney General would be the person bringing the action personally, actually rocking up to the courts and presenting both sides of the argument. Now, and the second one is Bag's case, which I believe is older. I just love the quote at the end from the reporting series. That's Strange, I think, or the ER reporting series, where it's got removal without hearing the party removed is bad. That was the summary. But really, these things come from a very deep-held, deep-rooted sense that before a person is found before a court or a decision is made that is adverse to them, be it in the civil sphere or in the criminal, being found guilty of an offence, it seems like a really bad thing to not give that party the opportunity to rock up, to actually tell their side of the story. There is an Irish activist, what I say, present tense, past tense, activist, called, I think it was Michael Collins. There was a couple of them, Casement. Casement you would have come up, you actually might have remember from statutory interpretation. He was the guy who was hanged on a comma. Does it sound familiar? Van might have talked about that. There was an old common law statute that said that it is an offence to corrupt the use of the realm, or to say bad things about the king and His Majesty's realm or beyond. And they weren't too sure whether there was a comma in that sentence or not. And so this guy, Roger Casement, they had to go, supposedly, deep into the archives and find the old handwritten versions to determine whether there was a comma, because he'd done some sedition against His Majesty the King, but he'd done it elsewhere, outside the realm. And they couldn't work out. And basically, if there was a comma, he was going to get hanged, and if there wasn't, he was going to get off. And so they rock up to the archives. You've got to appreciate, the judges and the prosecutors all wanted this guy to get hanged. And they're like, oh, yep, that mark, that's definitely a comma. There you go. That's what happened to Sir Roger Casement. But another contemporary of his, I believe, Collins, who made the comment that, look, I have been I've been charged with sedition against Her Majesty's realm by His Majesty the King. I've been charged. I've been tried. I've been charged in my absence. I've been tried in my absence. I've been found guilty, sentenced to death in my absence. Well, why don't they hang me in my absence as well? Ah, hilarious. Yeah, that was really lame. But anyway, that is a quote from I believe it is Michael Casement. But the idea is that, look, you need to be able to rock up. You need to actually be able to produce evidence to your defense. And that's something that we have this deep held feeling that that's the correct thing. And this is manifested in, again, differently in different texts. If you read this, judges will describe it in different ways. I have taken Jamie's ones that he'd had there, which is taken from one of the texts as well. And I'm going to analyze this in terms of 6 aspects, 6 requirements to satisfy this hearing rule. And they are that a person has to have adequate prior notice, that material needs to be disclosed to that person, that person has to have adequate opportunity to address the issues that are put before them. That party may or may not have some form of right to have some representation in some circumstances. Again, a party may, possibly may not, have a right to cross-examine. You guys know what cross-examination is? Right, basically, when the other side puts forward a witness, your right to question that witness. And finally, we'll talk about reasons. Now, I believe in the subject we do reasons again when we talk about freedom of information. So, annoyingly, we have to go forwards in time before them and backwards in time throughout the subject while we're learning. So, I'm going to talk a little bit about reasons, but not in great depth. But really, these 6 things, and this 6 things, if you were talking about the hearing rule in whenever it is, late October, early November, when you're scribbling through your 2-hour exam, I think it's helpful to classify these 6 things as 6 distinct points, each of which will be allocated some amount of marks, possibly. Unless things clearly don't apply. For example, it's a hearing on the papers. You guys know what on the papers means? Anyone heard that phrase? What's a hearing on the papers? Okay. You guys know you can have a hearing. For example, has anyone been to QCAT for residential tenancy or other things? Anyone had a dispute that requires to go to the tribunal? Well, you can have a physical hearing where you literally rock up, and the other side rocks up, hopefully, and a member comes in, and it kind of looks like a court. They sit up the front, there's a person taking notes, you give your side of the story, they give their side of the story, and they come to some form of result. That's what we envisage a classic hearing to be like. Most hearings, though, a good chunk of hearings are actually done over the phone. So you will do, and that's the technology. We can get 3 people on a phone call, and they can talk one at a time with the member in the situation, sort of adjudicating things. Other times, though, they can say, well, look, how about you just submit all your paperwork? You submit all your paperwork. If you guys are both happy with it, we'll just decide it on, and that's what they say, on the papers. We don't need to have a physical hearing. We'll just give all of the documents to the relevant person making the decision. And it can be, again, it can actually be court matters you can have heard on the papers, and certainly tribunal ones as well, because it just saves a bit of cash, saves a bit of time. If both parties consent to it, why bother actually rocking up? If both parties are happy with that. That's a hearing on the papers. I think I've referred to that a few times. All right, prior notice. Yeah, you'll find, again, there are six items in this area. We're talking about the hearing rule. Oh, question? Oh, no, not question, no. Some of them the courts have talked about in a great deal of depth, others not so much. Prior notice, you would think, is just a complete matter of common sense. A person needs to know about something with enough time for them to read what it's all about, to determine whether or not they have to rock up or do something in order to uphold their own legal rights, and to do the mechanical steps for doing this. Filling in the forms, getting them checked, finding legal representation if need be. That's really what this part is about. It is a matter of common sense. And these things are mapped out in statute. And you guys are probably aware that the courts take a long time with things. Courts take a long time getting things done. And a big chunk of that is this part. For those, I don't know, if some of you might have done civil procedure, maybe not, maybe next year. Probably only a small subset of you would have done it. A lot of that is timeframes. They're very carefully mapped out in the UCPR, and it is a big problem in professional practice if you get it wrong. Rock up and you realize that you're out of time on something, because people's rights change when timelines expire. And I love this case, this Thames magistrate. It's a ship's captain, didn't even speak English very well. Was given notice that he had to rock up, was given notice in the morning, all right, that he had to rock up to the magistrate's court at 2 o'clock that same day, and the boat was leaving at 10. Didn't speak English very well, had 3 hours to prepare, and the boat that he was on was going to go, because he was the captain? Some senior person on the boat. Yeah, it didn't work very well, did it? The court said, this is just a little bit silly. You need to have some form of notice. Now, in the case of Sales, that was a migration case involving a permanent visa that was refused. They gave the guy 14 days to respond to that. And the court said in that situation, 14 days is manifestly inadequate. That is just not enough time to fully, functionally take all of the issues into account and prepare a reply to this. Now, it is important to note here that these things are obviously going to depend on how complex the matter is. I had a matter with the Australian, I think it's the Qualification Standards Authorities, AQSA, I think is what it's called, and to do with a matter involving a complaint of a training provider, not JCU. I'll probably talk about it later in the semester, actually. And they gave me 7 days, in which if I didn't, they'll close my matter if I don't respond within 7 days. And the first thing I did, very first thing, was reply and say, look, this is, it may seem to you that this is simple, but actually it's a far more complex area of law and facts, and I have to gather a whole bunch of information, and I've got to go and go through the dispute resolution process of that third party, actually go through that training organization's dispute resolution process. There's no way that's going to be done in 7 days. Can you have more time? And they changed it, and I said, oh, can I have 3 months? And they're like, no, you can have 28 days. Oh, okay, that's fine. Always ask for more than what you actually need if you don't need things done urgently. Okay, that's it. Any questions on that? It really is a matter of common sense. The more complex the issue is, the more time natural justice will afford you to read those things and to interpret them and form your argumental response. One of the nice things about administrative law, by the way, is that it overlaps. There's a lot of overlapping with other areas, and so it's a useful. And I quite enjoy the subject matter because, from my perspective, I get to draw other areas, tort, contract, equity, into it. And this is one of those times where we actually draw some material from criminal law. I'm not going to ask if anybody here has ever received a summons. That's not a very fun thing to receive in the mail, is it? It'll be presented to you through personal service. But the key thing to note, the criminal law guys, and for those that do end up practicing in that area, you'll become very aware of what needs to be done in terms of giving a person enough information to answer a criminal matter. When you look at or are given something by the police, either through a summons to appear, or I think they have a little statement as well that has all the factual information. I can't remember the form. They will tell you all of the relevant things that you need to know, and they will map out and explain to you what the particular elements of the offence are. Because as you guys, for those that have done criminal law, may well know, you can have one section in the code, right? But it may have 14 different offences listed in it. And so they have to be really clear when they're charging you, oh, this is actually, for example, this is malicious grievous bodily harm, and it's item C on this list and item F on that list. You guys remember that GBH you can do in a whole host of different ways, and you can cause grievous bodily harm in a whole host of different ways, laceration and dislocation and so on and so on. So it's like a little, I refer to as the Chinese menu charge in the criminal code. You pick one from this and pick one from that. As a result though, when you receive the charge, you need to know, oh, it's this section here and that section there. This is the exact thing that I'm being charged over. And the courts in criminal matters construe that really, really narrowly. You need to know, and more importantly than that, you need to have all of the information there in order for you to make an actual decision. You have to look at it and read it and go, oh, is this worth contesting? What they've also said, though, is we don't want to have a system of justice, system of law, where we have trial by ambush. Anybody watched the last episode of John Oliver's Last Week Tonight? Anybody watch that show? Has anyone seen that at all? It's really, really good. I do recommend watch it. Guys, about as pretty as I am, but he's very funny. Much funnier. And we're talking about this trial by ambush. You guys have heard of that phrase, I imagine? It's where both sides don't give each other information, key bits of information, so they rock up to trial, and one side is clearly going to win. So much so, the other side would never have gone to court if they'd known they had this smoking bullet piece of information that renders the entire trial pointless. Used to be the case with tax decisions. When I learned this as a young lad learning tax as part of a business degree, that was how the tax offices in New Zealand used to operate, where either side didn't have to disclose, so they would rock up and just dump all this information on the other side on the day of the hearing. And so much so that neither side, or one side or the other, would never have gone to the hearing. So they, as part of this, the courts have said, look, this is dumb. It is inefficient. It is not a practical system of administering our system of law and really facilitating real justice for each of the parties. As a result, in matters, not just administrative law matters, in all matters, you need to give adverse material to the other side. And if you don't, that can be a breach of national justice, provided that, again, is credible, relevant, significant. Some things, though, you don't. For example, migration case. If a person comes and they arrive in, let's say, seeking asylum on Australian borders, if they are from North Korea, can we draw any information from our background knowledge of North Korea? Do we think that North Korea might have the sort of government that a person might reasonably flee from prosecution from? Maybe. Probably. And so we use the phrase notorious information. That information doesn't actually have to be disclosed. as part of this process. It's not a breach of natural justice if you forget to put in, oh yeah, by the way, the North Korean government sucks. You don't have to do that as part of the process of doing it. Again, in Maya's case, it involved, I believe there was a change of government in, I'm not sure which country they were from, Bangladesh? I can't remember. There'd been a change of government. And so there, when they're talking about whether things are notorious, well, look, if you're fleeing persecution from a government, all right, the type of government actually does matter for these sorts of cases. If you're fleeing from the tyrannical Canadian government coming to Australia, you're probably not going to get asylum. But whether or not the government is noteworthy as being tyrannical, or possibly it's changed. In fact, I think it was Myanmar, might have been Burma, where the government changed. Government and the style and mode of government had changed. And that didn't form part of their argument. That's not going to be sufficiently noteworthy. That must be put into the process and be disclosed. And not doing so is going to be a breach of natural justice. Okay, just as a practical legal point, sometimes you're going to have confidential information. You guys, most of you are going to be lawyers. You are going to be dealing with confidential information all the time. Stuff that we can't go to the pub, talk about with our mates. Now, one of the difficulties with this, of course, is that if the information is in confidence, that it isn't usually going to be a breach of natural justice, right? If you've got competing duties. Oh, hey, we need to give this to the other side because it's material to their defence or this decision, but it's confidential in nature, all right? How does this work? How do we resolve this competing duties? And what the common law has developed and said that, look, as a practical, mechanical step, you can give this information to their properly appointed legal representative. So you as the lawyer are going to end up being entrusted with confidential information from the other side, the decision maker, that you can't tell your client. Just think about it for a second. You can be given information that is in confidence. You as a legal practitioner, where is your overriding duty to? Is it to your client? No, it's to the court. As a solicitor or barrister, your overriding duty is to the court itself, the administration of justice. So that just as a practical step, is something that they can use to bypass the situation where you've got competing duties between the terms, things that are in confidence but need to be disclosed. Okay, that's all I've got to say about that. And before I mentioned this phrase, a hearing on the papers. There isn't, strictly speaking, a requirement, and again, when I say requirement, in terms of breaching the hearing rule as a component of natural justice, it isn't strictly required to actually have an oral hearing in most situations. Okay, it's not strictly speaking a requirement, but the court has said that, look, in some situations, it is going to be necessary. And we can kind of think this, again, as a matter of practicality. We know how court systems work. If it's the sort of matter where you've got largely a legal argument, and they've got a legal argument, and the facts aren't really in dispute, that can be heard on the papers. Here's our argument, there's their argument. Judge, you work it out. That's not going to be problematic in terms of having something heard on the papers. It is going to be problematic if witnesses need to be called. And in particular, witnesses need to be called and there's some form of cross-examination that's required. And these things are going to require having a hearing and not having a hearing. Electing as the decision maker to not have a hearing can be a breach of natural justice as a result. And the last one is to do with credit, reputation, and trustworthiness. If a person's personal reputation, and again, you guys remember doing for equity, you would have done this, companies above a certain size can't be defamed. We're not concerned about public, larger bodies, we're concerned about the reputation of individuals. If there is some real possibility that somebody's credit is going to be, a person's going to be brought to disrepute as a result of a particular outcome, it will be a breach if that isn't actually done in a public hearing, a public forum, where a person's given that opportunity to, to present themselves. Anyway. Do we have a right to a lawyer in Australia? Who reckons yes? Who reckons no? The answer, Dietrich and the Queen, no. No, you do not have an automatic, indefeasible right to legal representation. We do have systems in place to try and resolve the injustice for people doing that, largely to do with things like legal aid, and that is means tested. I, when doing community legal, would rock along to the, I think it's the Women's Centre. What's the building on? It's near Stockton. Go further up Ross River Road. There's a centre there. That's a homelessness hub, and people come in. And I do remember one time with one of the solicitors, who's actually a lecturer these days as well, and we had a particular matter come in where a person who was admittedly very upset, very distressed, wanting some help, some legal advice. You know, we're giving free community legal advice to do with that person's a tenant in that person's house. All right, and that person, and she sort of said to us, "Oh, look, you know, things have got so bad, I've had to go and stay in my other house." Like that, and I'll never forget this. Where we had a couple of graduates as well, grade students doing the PLTs, who were all like, "Oh, don't worry, we'll go and help you. We'll get back to you and we'll sort this out." And after we left, that person had left. The acting solicitor said, "No, woman's got 3 houses. She doesn't need free legal representation. She can go and pay a lawyer." And it's something that sort of the bubble just burst in the room and realised, oh yeah, that's actually a really good point. That is a good point. Legal aid, things are means tested. Now, while strictly there is no requirement, look, if you're going to go to the Supreme Court to represent yourself on a manslaughter charge, the state will step in. The state will find someone or somebody will step in to go through and do these things. And as something for you guys as future law students, I have gone to the intake where they get the high school kids in. I'm a terrible human being who asks the question, so who here is doing law for the money? And you get some of the honest ones will put their hands up and right, I'm going to burst that little bubble right now. Part of contemporary legal practice is doing good things in the world. And part of the things you guys will have, and again, we're doing administrative law. We're going to learn how to do all sorts of systems to make people probably hate us because we're going to make governments do their jobs, bend them to our will to some extent. But the flip side is that you guys, most of you, hope either in your capacity as paid legal professionals doing pro bono work, or as part of your PLT requirements, professional legal training requirements, or as part of your ongoing CPD requirements, or just because you're good people, probably be involved with doing some form of unpaid legal work at some stage. You guys are going to have skills. Those skills are going to be scarce, and those skills are going to be valuable to everyone in society. We live in a society. We have legal problems from time to time. So just make note. Also make note, just as a side point, don't give legal advice to your mates. They can get you in trouble. For those that have done civil procedure and legal ethics and trust accounting, the rules, you're not insured to do so. Make note. So please take that, everything I've just said there with a grain of salt. But I hope you guys do at some stage. It's certainly very rewarding. Okay. So Dietrich, that was the case where they said, look, strictly speaking, there's no right to legal representation, but where things are complex, the government really needs to step in and to help people out. Have any of you guys been to the courts where you've seen people self-rep? I'd say, some of you would probably say it with a bit of a smile on your face. Some of the most enlightening, is a nice way of putting it, entertaining, at least from our perspective as spectators, but very frustrating from the perspective of the actual judicial staff, are people that self-rep. People that go to the courts, particularly going into the superior courts as self-represented litigants. You have the right to do this, and the courts have to take specific steps to make sure that you can, have an opportunity to do and have your argument and raise the Magna Carta on your issue of your speeding fine. At the end of the day, it may not change the result, but the courts have to bend over backwards, and the registry staff, to ensure people can do this, even though we recommend at every single stage that you don't. You actually go and find representation. And you will hear these horror stories, usually from North America, about people going, can't afford a lawyer, so have to go and plead guilty. And that's horrible. That's not a system that's not a society that we want to have. Okay, anyway. Okay, cross-examination. Again, in matters that are complex and where witnesses are being called, usually, if a witness is called, and you're on the other side, it's not your witness, you get a right to cross-examine. That's to ask questions of that person in response to material that they've been asked by the other party and things that they've said. Now, again, it can be a breach of natural justice if you've not given that right, but the courts have said that, look, that really only applies in situations where the proceedings are really court-like in their nature. It's two sides bringing a matter, bringing their own witnesses, and conducting it in a court-like style. It's not quite so, it's not going to be a breach, and if it's not quite so appropriate, it matters where the tribunal itself is operating in a more inquisitorial mode, where they're the ones asking the questions. And if you think about this, when you go to tribunals, members are instructed to actually operate this, to try and to reach some form of justice. They will ask questions. Judges don't ask questions, substantive questions of law or fact of the parties in courts, but in tribunals they do, and they can. So it's really an administrative function. So the closer it looks like a court, that looks and smells and acts and operates like a court, it's more likely not being given the chance to cross-examine, even explained the process of cross-examination. I appreciate that's not a term that lay people use. That in that situation it can be a breach of the hearing rule. Reasons. I believe we'll talk about reasons later on when we talk about freedom of information. Actually, at common law, you don't have to give reasons. My spectacular fail in front of Magistrate Smith was something like, Mr. Walker, I reject all your submissions. I don't even know whether he rejected my submissions of law or my submissions of fact, because I had to provide evidence, because I was the offendant. Either way, there's no common law duty on decision makers to actually tell you why, at common law. All right, now, in statute, there is, and it'll often vary in terms of how and where the statutory instrument is set up, in terms of the actual reasons they're going to give. They often put them in regulations and schedules, and what they're going to say in each one of those. And note that the Acts Interpretation Act actually says, look, if a body making a decision needs to give written statements, they have, what do they say? They must also set out the findings of material questions of fact. So the statement of reasons has to list the questions of fact and how that applied to the relevant principles or laws or rules that they're using in order to reach that final result. And again, there's usually a statutory remedy. It's a breach of natural justice under the various statutory frameworks if that isn't done or hasn't been done sufficiently. All right, so what do reasons have to have? Well, the whole point of reasons is for a person, a citizen, a person who's been aggrieved by the decision, to be able to look at it and read it and go, oh, that's how they came up with that. I might not like it, I might not agree with it, but I can see how they've done it. Really, that's this key part. We need to see what the decision-making steps were, or the process was, in order for us to then go and determine, oh, well, hey, if we don't like this, let's go further. Let's go and peel it, or let's seek some sort of review on it. Let's go through an internal process or an external one. We need to be able to see what the mechanics of this is in order for us to make that decision. I actually love that, the phrase, that middle one. It needs to adequately disclose the intellectual process that results in a particular determination. Okay, and make note, sometimes when you're getting particular reasons for a decision that involve some form of code, framework, standard that involves a particular, like an industry standard or a professional association, they need to explain clearly how, usually it's involved with conduct of a person. If you're a doctor, you're falling below the standard of a reasonable, competent doctor. Under the doctor's code of conduct, they need to actually identify those and explain them and tie the two together. And of course, that part needs to be clear. And so, for you guys, student academic misconduct. If any of you, fortunately, law students generally pretty squeaky clean. Why? Because law students that do bad things end up in the Queensland Court of Appeal. That's very expensive and stressful. But as part of misconduct allegations and investigations, and then if a determination's made, it has to tie back to the very specific things that you are required to do as a student at James Cook University. And again, all of those things have to first explain the relevant facts. This actually is a skill for you guys as lawyers, even if you don't end up being government lawyers, being able to restate the facts, key facts, in a particular structured order, and removing the irrelevant rubbish. Actually stating the important facts that are used for a particular analysis, be they a decision in the administrative sense, or if you're giving advice to a client on a commercial or a criminal matter. Being able to do that is a really important legal skill like this. Okay, given we've got not much time, and there are not many slides to go, which is good because there's not many minutes in order to go through them. All right, so we talked about that. Those last 6 points are the hearing rule. The rule against bias is this idea that, look, if you rock up and you rock up to court and you're sitting in front of the judge and you realize that the judge is a part owner in the company you're trying to seek a remedy from, that's a bit of a problem. And it's a long-standing rule, 1,000 years old, that you can't be the judge in your own matter. It doesn't make any sense to allow judges to have some form of interest in the result. Okay, and look, it's unlikely in situations you've been, these things are going to be obvious, but, and the courts have said this in Australia, that sometimes it's not quite as obvious as it might seem. For example, if you were a bank, ANZ, and you're suing another big bank, Westpac, you're having a big dispute, you're off in the full federal court, what are the odds that one of those federal court judges has a superannuation fund, which, as part of their big package, owns some of the two of the four major banks? Pretty high. It's pretty high. So this case of Ebner, they said that, look, just as a practical consideration, look, you're not automatically disqualified. It's actually quite hard in Australia, particularly with index funds and superannuation systems that we have. You're going to have judges are going to have pecuniary interests in things. And so it's not the hard and fast rule that it is in other jurisdictions in Australia as a result. That's Ebner's case. And just make note that when we're looking at bias, it falls into two categories. Actual bias, which is where the decision maker's mind is somehow changed or swayed by this having some form of interest in the subject matter. That doesn't come out very often. Don't get me wrong, people try it. Self-represented litigants try this all the time because, oh, your honour's just on the same side as them because you like greyhound racing, and people try it. But from that very practical consideration, it doesn't come up that much. What can come up a lot more is this idea of apprehended bias, and that is where a third party, a reasonable third party, would look in and think, well, there might be some aspect of impartiality. That's this idea of this apprehended. It's not, remember, the law is being seen to be done, not just doing things. Would a reasonably minded third party look in and think that there was some form of interest? It's like a step back and looking at this process from outside. It doesn't really matter whether it actually is or not. Would a reasonable person think that? All right. Okay. One of the things about natural justice and procedural fairness that I really want to talk about, and I'm sorry, I'm just urgently running out of time at the end of the lecture, is that natural justice and procedural fairness applies to non-governmental decision making. This is a really important point for all those that may be involved in things like the student associations at James Cook University, be it the parent one or any of the subsidiary clubs or societies, not looking at people in the room. Now, what the courts have said is that, look, natural justice and procedural fairness can apply to these things as well. It can apply to these private bodies. And if anybody's read the Law Student Society Constitution, probably has systems of dispute resolution, or it doesn't, I don't know. It's been a long time since I wrote it. Most of them do. Most of the things in order to be incorporated, and which means that you fall under the Associations and Corporations Act, has to have some process for members to resolve disputes. These things come up. They come up a lot. And again, as someone spent a bit of time doing community legal, people rock up to argue that they've been kicked out of their train club, model train club. What remedy can I get? And usually the best piece of advice, by the way, is go find another train club. Sometimes that doesn't work if there's only one train club. But the courts have said that, look, natural justice will apply in these situations, and you can go to the court and ask them to actually give you an order for a breach of this. These things can apply. There was actually a case, couldn't believe it, I was doing some research on this, from this year, Justice North. Somebody got kicked out of the Proserpine Golf Club, had to go to the Supreme Court in Townsville to get them to let that person back into the Proserpine Golf Club. Justice North wrote quite a long judgment too. But other things you might not at first think the law should enter into. Deducting points from your team in a competition of some sort, right? These things, you've got to follow the appropriate process. And the process, and often in these times, it's actually dictated by the rules of that particular association. And or even sometimes non-incorporated associations, things like churches. They will have certain rules that need to be followed by members. These things can be upheld in the court system. You actually can go and seek some form of remedy from the court, declaring certain decisions of those bodies invalid in some ways, or to make them or change them in some way. What's another one? Land co-op and surf lifesaving clubs. Look, the key thing about this one here, I just mentioned this, D'Souza and Royal Australian, that's a doctor of some form. Sometimes being a doctor, if you think about it, or being a solicitor, although to be honest, good luck challenging the QLS. They have all the lawyers. 2 minutes. So just make note, if you happen to know somebody who's a doctor or a vet or a nurse, these things have systems. They have to go to tribunals, they have to go and seek some form of review of decisions because it impacts you. If you train for years and years to be a nurse, then they make a decision, says you can't be a nurse anymore under, for this, and that reason, they better be damn sure that they've followed the appropriate processes for that, the nursing society or the appropriate statutory framework those things are founded under in order to do that. Okay, very, very last slide. I think. I hope, yes. Futility. Natural justice, right, is a practical remedy. It is a practical remedy. So it's not a remedy. It's a practical, mechanical step that the law takes to ensure, good governance in a good society. They will not do things, grant a remedy. Sure, if in situations where there has been a breach of natural justice, but the result's going to be the same. Oh no, the Law Student Society didn't give that person who defamed someone else adequate notice before kicking them out. Okay, let's go back, give them adequate notice again, and do it. The result's going to be exactly the same. The courts will not do things that are going to be futile. And again, that's why with things with non-for-profits are difficult, usually because there's a relationship-ending dispute about things. The people and parties just will not get along from a certain point in time. And so the actually granting a remedy is going to be futile in those situations. That's Stead's, the principle in Stead. Stead? Either way. Okay, sorry this took all of lecture. I tried to encapsulate this all into one. So there's one docx file that's sitting under week 4. And I'm hoping that that will encapsulate the key things you guys will need to know for going through and doing your exam. That's why I try to do them like that. Okay, guys. See you in very soon. Very soon.